Okay.
Well, hi, everybody. My name is Michael Montag. This is Ashley Yorra. She can speak for herself, but we're both partners at Vial Fotheringham, and HOA law is our thing. Could probably give a longer spiel than that, but I think you know who we are and you know what we do and you know why you're here. So I'll start with a little bit of housekeeping. Probably getting a little bit tiresome for everyone who's been doing this now for, practically a year and a half. But if everyone can stay on mute, that'd be great to help with all the background noise. We're happy to take questions in the chat. That's usually, the chat feature is usually the best way to do that. And we'll keep track of it as we go. So don't worry, we're seeing your questions. We might not answer it immediately and might work it in at a different point in the presentation than when you ask it, but we'll do our very best to get to everything. We're going to try and cover, pretty much everything in the HOA universe today. So if we don't get to something, just reach out to us. Our email addresses will be at the end of the presentation, and we're happy to answer additional questions. Any other introductory comments, Ashley? Otherwise, I'll jump in.
I feel like we should talk about the title. So it's Pets, Poop, and Pools. And what the heck is that? My goodness, that makes my eyes hurt. So we're gonna touch on all of those things all together. I have gotten recently a ton of rule violation requests and information about that. It's something that's happened a lot of, and so we're definitely going to talk about pets and and poop, and then pools is also a really hot topic. But before we get to all of that, let's look at this really eye-bendingly harmful slide. Hey, the pandemic is waning. Let's hope it stays that way. And yeah, get off my lawn.
Yeah, I don't know about anybody else, but every spring there's kind of this moment where this massive exodus of our interior lives, and everybody heads outside and starts interacting a little bit more. And that is especially exaggerated this year since everyone's been in more isolation than normal and really, really staying home. We don't even remember how to interact with our neighbors or anybody else. And it seems to us that there, how should I say it? Manners and social graces and patience have worn thin over the last year and a half.
They don't exist anymore. Didn't you get the Emily Post, informational blog? You just don't have to follow manners anymore based on what I've been hearing lately.
So enforcement issues, kind of the get off my lawn, your dog's pooping on my lawn, kind of complaints in our associations have been through the roof. And that's a normal thing, but it seems like it's been especially heightened this year. And so we figure, we'll start with a COVID update because that's pretty important, and pools are a big part of that. And we'll talk about them specifically as a springtime issue and a pandemic issue for sure. And follow that with kind of a refresher on the fundamentals of rules enforcement and how we deal with not small, I won't say small violations, but kind of, the day-to-day issues that we're seeing in terms of rules violations and the need to enforce or not enforce some of those. So, yeah. Oh, go ahead, Ashley.
If we're going to talk about, pandemics, I was going to say, I just got out of an arbitration. And there was an owner who isn't paying their assessment, and they're claiming it's because they can't use any of the amenities. And so, this is timely because, most associations are looking at opening up their amenities again. Luckily in Oregon, there is no right of offset by the state statute, by state law. So even though associations may have closed things down, like their common areas, their pools, It doesn't mean that owners don't have to pay their assessment. And so, but I know everybody's opening these things up right now. So let's talk a little bit about how that's going to vary this year, because it's we're in a patchwork quilt of restrictions right now. Michael?
Yeah, and that's really that last statement. We're in a patchwork of restrictions is really sums it up. Probably most of you have been following along with the various risk levels, and for a long time, most of the state was kind of in lockstep in terms of everyone was in extreme risk or everyone was in high risk. And now we don't have that, and we have a lot of mixed messaging in terms of mask requirements and enforcement of mask requirements and vaccination requirements, and really it runs the gamut. I'm in Clackamas County. Our office is in Clackamas County, but not by a lot, and we're in high risk still. Everyone else around us, if I go a half mile up my street, I'm in Multnomah County, and it's, I think, low risk at this point.
Low risk, and so is Washington County. And so are, I believe, over 21 counties in Oregon now are in low risk.
And there's a big chart that the state has online that for every risk level, it says what you can and can't do, at least in broad terms. And some of the main variations are the size of your gatherings that are allowed, and what indoor and outdoor sports and activities are allowed. And as we all hear, I think dining, restaurants are a big issue. I've personally found, even here in Clackamas County, there's in the restaurant scene, there's some rebels out there that are kind of following a mixed bag of rules. And I think I've seen that with HOAs as well, in terms of requiring masks, not requiring masks, where, capacity requirements and things like that.
Well, and as things are opening up, I'm going to touch briefly on masks. Oregon is, I think, one of the only states that has made a requirement to place the onus on businesses to allow people to take off their masks. So the base rule in Oregon, until it gets changed, hopefully here in a few weeks, but is that masks are required. So masks are required if you're going into businesses in indoor settings. And if a business wants to, they can enact a policy that allows them to verify that someone has been vaccinated. And upon verification of vaccine status, then they can allow people, that person who's vaccinated, to take off their mask. So the base rule is masks are still required indoors at businesses, but based on verification and the association and the business policy, including associations, then people may be allowed to remove their masks if they're vaccinated and have proved it.
So Ashley, are HOAs and condo buildings businesses?
Well, here's the thing. Under the definition of businesses, I think that they're going to fall into that. I think the more interesting question is how are associations able to enforce this? And I think it can be really problematic. And that's why I said Oregon's one of the only states that have made it this way. Up in Washington, it's a kind of, if you're vaccinated, you can take your mask off. We're going to trust you to know if you are or aren't. And that way it's not up to businesses. But here in Oregon, I think if you're in a condominium building, you probably fall under businesses. I'd love to hear an argument you don't. And so it's probably a good idea to get a policy in place. And we've been, helped associations try to do that. The other thing I worry about is still a hot flash point, these masks, and making people take them on or put them on or take them off. And so, as always, I always advise associations, don't what I call breach the peace, meaning don't get into fist fights, don't get into situations that are going to cause issues. If there's a problem with a mask, you should have rules in place that allow you to deal with it in a non-confrontational physical manner.
Yeah, and we've had some enthusiastic discussions as a firm for all of us who practice in this area about what these rules apply to in terms of HOA common areas, clubhouses, common entrance ways in high-rise condo buildings, that sort of thing. And it has been kind of hard to understand because the state's guidance hasn't been explicit in a lot of ways in terms of where does an organization like an HOA fall. Businesses are one thing, and you guys, in many cases, you're a quasi business, you are corporate entities, but churches, recreational establishments, dining establishments, those are kind of broken out and have clear individual sets of rules. HOAs don't, for the most part. And pools there has been some guidance related to pools where it does specifically mention HOAs, but it's been a tricky situation. A question in the chat, is it having to show proof of a violation of HIPAA? So it's asking for someone's vaccination status, a violation of HIPAA. And the answer is no, for a couple of reasons. One is asking means that somebody is voluntarily sharing the information. That's never a violation of HIPAA. But the other more important reason is that HIPAA doesn't apply to HOAs. It applies to a limited set of healthcare providers, insurance companies. Frankly, I don't know the whole universe that it applies to, but not HOAs. I know that much for sure.
But so, as we're talking about violations, we want to talk about privacy, and something that I do think is important, that I don't recommend that associations keep pictures or proof of vaccine cards or anything like that. I don't think that that's a good idea. However, I still don't think that's a HIPAA violation. But I think it's important, to be careful about that. But I agree with Michael. It is not a violation of HIPAA. And yeah, I think there's another question here. I think that HOAs probably fall into the business category. You're a nonprofit corporation in most cases. I am happy to, if somebody can prove me wrong, I'd love to see it.
And, I think there's been a shifting tide of opinion on enforcement, and okay, well, what's the state really going to do in terms of coming down on HOAs? And throughout the pandemic, I've not personally encountered an enforcement situation where the state or a county or a locality came down on an HOA, but I have heard various stories and different approaches among the various counties in the metro area that suggest that some counties, Washington County in particular, has pretty directly said that they intend to enforce all the mask requirements and all the various COVID-related requirements against HOAs and take it very seriously. But now, I was
going to say, and even then, there's a number of businesses that are not HOAs. I'm talking about businesses that I'm sure everybody's walked in. It's they're not enacting the state law as it's been given.
Yeah, that's right. And there's been, now that the governor has said, once we hit 70% vaccination, I'm pretty much going to roll everything back. And as we approach that, I personally have seen, a decline in the strict compliance and enforcement out in public, in businesses and things like that. And I would imagine that would correlate to also a decline in the state or any particular county's desire to spend a whole bunch of money trying to enforce something that's going to be gone in a couple of weeks anyway. But you never know. Government entities surprise me all the time, and the rules are still in place.
Yeah. So it's important. It's, I think it's really important to note that those are in place, and then different people are dealing with it differently. And, as of the state of this presentation, it's in place. I know that the state is hoping that by, I think the date was June 24th, if I remember, they're anticipating that they'll be able to release a whole, that they'll be able to take back a whole bunch of the COVID precautions altogether, because at least 70% of adults over the age of 16 will have had at least one vaccination. So, yes. The other thing that I want to touch on that is really exciting, news alert, fantastic. As these COVID restrictions are getting rolled back, one thing that does not need to get rolled back are virtual meetings. There is Senate Bill, I believe it's 329, which was passed by the legislature and signed by the governor, and it gives associations who follow the requirements, and there are certain requirements, the right to meet through electronic means. So even after there's no state of emergency in place, associations can still have their monthly board meetings over Zoom. They can have their annual board meetings over Zoom or whatever electronic platform you want. But there are certain notice requirements. You do have to give notice to the owners, and you do have to let them log on and hear what's going on. And in the case of an owners meeting, you have to allow them to be able to be heard as well. And so this is a huge, I'm going to say, step forward for associations. And frankly, I think it's really exciting, because one thing that I was surprised at was during the pandemic, I saw board meetings being better attended than I'd ever seen during my professional career. And I think it's because of this virtual component. People, owners could tune in, turn off their camera, sit and make dinner or whatever they wanted to do, and listen to the board and hear what was going on. And I think, I could be wrong, but I think a lot of boards were really excited about the kind of involvement as well. And so I'm certainly excited about the future of having virtual board meetings and seeing the kind of owner involvement that we have seen for the past year. But we'll see what happens as things pick up and people are busy. Maybe it wasn't just the fact it was virtual. Michael, you want to add anything?
No, not to that. But I completely agree. The virtual meetings, I know there's a lot of Zoom fatigue out there, but man, I found it to be a really efficient tool for a lot of HOA related business. Personally have met with a lot more boards than I normally do, because it's a lot easier for everyone to log on to a meeting in the middle of the day for 30 minutes or an hour, versus figure out an evening where everybody can be there and everybody can, and I can drive out to wherever it is and, figure out childcare and the whole thing. And now that's not an issue. So I'm hopeful that continues and we can keep, having kind of increased interactions. So actually we have a, go ahead. There's
what is that log?
Chat.
Okay. Well, I was going to say, what's that login? It was Senate Bill, I believe, 329. Does that sound right?
Oh, I think so.
Yeah, I think it's Senate Bill 329. It was just passed and signed into law. It does not have a chapter yet, is my understanding. There will be an Oregon revised statute chapter that will be given to this bill. It hasn't happened yet, so I don't have a direct citation, but it is. It does go into effect immediately. So you want to take a close look on it. We've got a link on our website as well. If you scroll down, it's under the news area and it's right there, it's the first thing. And it talks, there's a link, it tells you the requirements, the notice requirements, the technology requirements, and you also have to give either board members or owners access to all the information necessary to make a decision either simultaneously with the meeting or before the meeting. So, there's a couple of requirements on there, but again, Senate Bill 329.
The other question in the chat is why we think an HOA is a business under the guidance, when a business is defined as being engaged in commercial, industrial, or professional activities. I don't have the definitions in front of me. There are some more provisions in the various guidance that are a little broader than that. But in any case, I mean, the fact is an HOA doesn't fit neatly into any of the categories. So it's a matter of figuring out what category do we expect the state to put an HOA in if it comes down to it. And in general, an HOA operates as a business. Many have employees, hires managers, and conduct business-like activities. And that's kind of the quick answer as to why.
Now I was going to say, yeah, the definition in the guidance is broader, and that's part of the issue. So it's, you look at the guidance. And so when we're talking about the guidance, as Michael mentioned earlier, we come to pools, and pools are specifically, HOA pools are specifically mentioned in the guidance. And so we do want to make sure that associations, as they're opening up, pools are following this guidance, because for some associations, it can be onerous. For other associations, it's not any big deal because they already have the technology in place. So Michael, do you want to talk a little bit more about the specifics, the social distancing rules?
Yeah, so pools have become a major point of opposition, argument, I guess, in HOAs I represent anyway. And that's because of a piece of the guidance it's a little buried, not super deep in there, but not right there on the surface. And many of you have probably heard about this, that in order to open any licensed pool in the state is required to have what's called a social distancing monitor. And that is a person whose job it is to be at the pool and enforce social distancing requirements. Kind of like the swimming pool is a middle school dance, and this person's the chaperone, making sure everybody keeps, arm's length away, or, the 6 feet. And that has been a very tricky thing, because many associations don't. If you have a lifeguard, okay, great. That person can be a social distancing monitor and can yell at everybody who gets too close. They can enforce capacity requirements and things like that. But for many of you, you don't have a lifeguard. You don't have, a staffed pool where there's someone obvious. And the guidance is actually, every time I go back and look, the guidance has something new on this, and sometimes it's not in the guidance. Sometimes it's in their FAQ section for pools, which at one point, everybody was thinking, oh, this isn't going to apply to HOAs. This doesn't make any sense. But then they put specifically in the FAQ, I think it was, that it was going to apply to HOAs. And it still does. It's still, I looked last night, we were thinking, well, maybe they're going to retract this guidance as the requirements get more relaxed. But even in low risk, nobody's at full capacity yet, until the whole framework is removed. So in order to open your pool, everybody is still going to have distancing and capacity requirements, and as of now, still has to have a social distancing monitor.
Yes.
Yeah. They've added some detail on what that can be. As of what I saw yesterday for the first time, after looking at this half a dozen times over the last several months, is now they're saying it can be someone as young as 15. And it can be a volunteer, and it can be virtual. It can be by video feed, I guess. If you have someone who's monitoring a video, I'm not sure what they're supposed to do if they see a violation, if they're monitoring remotely. But
they need a bullhorn. They from wherever they are sitting in there. They can bull. The gentleman in the black swimsuit needs to move away.
Right. And I think the way the system, I think a lot of associations have put in place, and I think it's probably the best, way to do it. If you're going to reopen and need to control your capacity, is a lot of, at least smaller association pools, that don't have a large capacity, especially with these limitations, they're kind of doing a reservation system, one group at a time. And you can have one of each group be designated as the social distancing monitor during their designated time. And I think that's probably the most functional way to do it for folks who don't have a lifeguard. And in that case, you're running a pretty low risk because it's a single group anyway. And even though the social distancing requirements still apply, there isn't going to be, sort of an outsider from that group who's going to start complaining that someone outside their immediate circle is too close to them. So I think it's probably the lowest risk way to do it.
The lowest risk might not be opening at all, Michael. But a lot of associations are opening. I actually am aware of associations where board members took turns being the social distance monitor. Literally, they each had a day, and they'd sit out the pool that whole day and play social distance monitor. So there's different ways of handling it. I think that board got a little overwhelmed.
Yeah, I would think so. And as Ashley said, the safest thing to do is to not open. And a question we get a lot is that an option? Owners do not like that, one bit. And when you say, this year we're just not opening the pool because even though we theoretically could. And yes, that is an option. Our position is that it's not, even if there is a pool and even if assessments theoretically take that into account, no one has a vested right for that pool to be open, especially if especially in light of these requirements and the fact that it imposes a cost or a risk to the association. Let's see.
I was going to say, so if an association does end up wanting to reopen and they've got provisions for the social distance monitor, there still is a risk. The risk is what happens if someone ends up getting COVID and getting sick, and the association gets named in some kind of lawsuit. So a couple of quick tips and tricks is the association always wants to talk to the insurer to make sure that it's fine to reopen. And then, they want to look at getting a waiver from people who use the pool to, basically a liability waiver, making sure that each owner acknowledges the risk, that there is this COVID risk and they're aware of it and they're choosing to undertake that, and that they're waiving their right to come back after the association. And so at this point, that's one of those recommendations that I think is just prudent to put into place.
Yeah, I agree. And I think a good thing to come out of opening pools in COVID is it's prompted a lot of associations to ask for waiver forms that they can use. And I've done quite a few of these for a lot of associations, and I put them together in a way that they can stay in place after COVID. It's not a COVID specific, it encompasses COVID, but it's not limited to COVID. And sort of a liability waiver, assumption of risk type form or sign up for anyone using your pool is never a bad idea. It's a pretty good idea. It protects you in a lot of important ways for against a lot of the things that owners sometimes do. We've gotten a couple questions about what if the pool's use is being reserved for all fully vaccinated people or all members of the same household. And at this point, I don't think the state's guidance on pools is affected by that at all. I don't. It's still in place without taking any of those things into account. So theoretically, the distancing, the distancing and the distancing monitor requirements are still there.
I agree.
Like as I was saying, if you assign someone in each group to be the distancing monitor, And if everybody from the same household is using it at the same time, I don't expect, mom is going to file a lawsuit against the HOA for not keeping dad 6 feet away from her while
Well,
the kids are.
that's a different issue altogether, Michael.
Yeah, or maybe that's exactly what'll happen. But in those sorts of situations, the requirements are there and you should still do it. But I think the liability and the risk is virtually non-existent, because the guidance in those situations is outdated. Frankly, they just haven't had a chance to update it.
And even with vaccinations, I don't think that the rules really contemplate vaccinated versus non-vaccinated. So again, I think it doesn't matter. I think you have to, the guidance, it should be followed across the board. Again, this whole, what we're talking about may be obsolete in a matter of weeks. In which case, I hope that we can come to you and tell you, hey, the framework has been, stripped back. But at the moment, that's what's in place, and that's what's happened.
And the same holds true for other common facilities, exercise rooms, clubhouse meeting rooms, all of the capacity limits, everything's still in place, and vaccinations aren't taken into account, other than theoretically if you come up with a system for checking vaccination status, you can do away with masks. Where do we find the guidelines? Deep within the Oregon Health Authority's website.
So I usually, just a few tricks, I usually Google Oregon Health Authority rules or guidelines and pools. And you can find them. Or you can also go onto the Oregon Health Authority website, and they are there. You just have to navigate your way to them. I don't have a link I can quickly throw in here because I don't have them up this second. So I apologize, but they are on there. Sometimes Google makes it a little faster to find them. I'm navigating through the Oregon Health Authority.
Remind me when we get a little later in the presentation. I do have some things up on my computer, but I'm the one sharing my screen right now. So I do have some links I can probably put in the chat here in a moment. I agree with the Googling. One issue I've personally run into, and this is true of Oregon and Washington, is these things have changed so frequently that it's always taken, every time I go back and look, it takes a little bit of sleuthing to figure out if I'm looking at the most current thing. The web folks, understandably, haven't necessarily always done a good job of taking down old things, replacing with new things. So old links are still active, things like that. So you always have to take a moment and figure out if what you're looking at is actually the current guidance.
What I was going to say, the other thing to watch out for too is news articles often link to the old rules. So I've found that too. So if you're linking from a news article, you always want to make sure it's the most recent version that you're looking at.
Yeah. So moving on from pools specifically, now we're rules enforcement. I mean, we're basically talking about this is the pets and poop section. This is the what do you do when somebody's doing something wrong? And Ashley, if I can stop sharing my screen for a moment, if you want to start talking about whatever you want to say about enforcement, I'll cut and paste some links into the chat for just a moment.
Okay, yeah, I'm happy to start talking about pets and poop and then rules violation. So as everybody's probably aware, I've actually noticed a huge uptick in pet poop in association, as well as pet violations, whether it's dogs who are barking at the wrong hours, or whether it's dogs who are fighting each other in common areas, or all kinds of different issues with animals recently. So the first thing that I always like to say is you need to figure out what the actual violation is of your governing document. Is it that somebody's not cleaning up after their pets? Is it that there is a noise nuisance because dogs are barking in the middle of the night and waking everyone up? Is it that there is some kind of other issue that animals are running off leash where they shouldn't be, where it's a leashed area? So the first thing that you need to figure out is what's the actual violation? What's the rule violation? Because then that's the issue that you're going to need to warn owners about. And so not all associations have rules covering these things. Many have rules covering nuisances. And so you can also kind of, fit it in under a nuisance issue. When we're talking about things like noise violations and whatnot, often you're going to want to have a procedure in place for an association, whether it's a rules enforcement procedure, or another document that explains to owners, that's been sent out to all owners, that explains how you're going to move through and what you're going to do for notice and how you're going to let people know if there is a violation. And part of this is about communication, and communication is something that's broken down in the pandemic a lot. But we want to make sure that associations are communicating with owners and saying, hey, here's the procedure that we're going to outline, and here's how we're going to what we're going to do, and how we're going to notice you if you have caused a rules violation. And so often, you're going to want to send kind of notice to the owners, or let the owners know before you take any kind of action against them. So let's say that there's a dog that's barking at late night. You get a complaint from an owner, and the owner, sends over whether it's audio evidence or, has been logging it along with the decibel meter to the board. And then the board is going to figure out, what rule applies to it. And then they're going to send notice and say, hey, you need to fix this violation. You need to help make sure that this is brought into compliance. Sometimes owners have no idea that this is happening. If they're gone overnight and their animal's barking, they may not have been aware of it, and so you're going to give them time to bring that into compliance. If it continues, then you're going to want to take further action. In order to fine in Oregon, you need to have a fine notice that has been put out, or what's called a schedule of fines, that's been put out and sent to all owners. So everyone's on notice of what's going to happen and what kind of fine they're looking at. They come in two main forms. One schedule of fines is any violation, you're going to get X number of dollars. If that violation continues, you get fined, Y number of dollars, and ongoing, continuing, then you get, whatever that other fine is, the continuous fine. I tend not to like those as much because, in my view, having a dog bark all night is more problematic than an owner who leaves their trash can out 2 hours later than they should. So that's my worldview. I tend to like schedule of fines that pick out issues that associations have. So, for instance, noise violation. The fine will be $50 for the first, $50 for each violation. If it's a pet excrement violation, $10 for that violation. Things of that nature. If you're off leash, maybe $25 for the first violation. And so it gives you a schedule so an owner knows exactly what to expect. Once you, if the owner hasn't corrected their behavior, then you need to give them, you can give them another notice saying you have a right to request a hearing, and this is very important. Under Oregon law, I have to give them a right to request a hearing by such and such date. I usually say give them 10 days, and if they don't request that hearing, then a fine will automatically be added to their account for that amount, and let them know. So there's a question I saw that just came up. Can you have a fine for other things such as attacking dogs and things of that nature? So I suppose you can. You need to have a rule, a rule. I suppose that can be a direct nuisance. So yes, you could have some kind of fine. When it comes to dog attacks or dog bites, I actually also think that those should be reported to the police. This goes from what I consider an association matter to being a life and safety matter, and that should also get reported to the police. So you want to make sure that these kinds of things are dealt with if they're a safety issue, not only at the you want to make sure that they're elevated to a police level as well. But yes, you could end up with a fine for a dog attack or a dog bite. You can also, let's see, got a couple other questions here. Besides getting information from other community members, how do we show proof of the issue? Well, that's a great question. And so if, oftentimes managers do walkthroughs and may notice issues. It may be that other members of the community report something. And you're gonna, as a board, you have to evaluate the evidence you have. If you have an owner who says, well, I don't have any records, but one night I heard a dog barking and it really annoyed me, and they don't know where the dog barking was coming from, then it's gonna be really difficult for a board to say, oh, well, we need to give a warning notice to so-and-so. If you have an owner who comes to you with a log and saying, I heard dog barking from the unit below me on these 5 days, these are the decibel meters, and this is when it started and when it stopped, or at least when I woke up and when it stopped, the board can evaluate those pieces of evidence as well, and they can determine how they want to move forward. So really, the board is determining, looking at the evidence and deciding how it's going to look. The other thing the board wants to think about, and this is important, if you have an owner coming forward, the board can say, hey, owner, we're willing to find this violator. But, if this is going to go all the way, let's say the violator says, oh, no, that wasn't me. This is going to go all the way and we have to take it to court. We're going to want to make sure that you're going to testify and that you're willing to talk about this in a court and to testify to these facts. It's really interesting how that can really reduce the number of owners who want to complain about things. Suddenly when you say you're going to have to, there may be a possibility that we need you to step up and we need you to testify and we need you to be under oath to say it, that X, Y, and Z happened and you saw it. Suddenly owners get a lot less sure. And they may say, well, I'm not really sure this is what happened. Or, well, I'm just guessing that this is what happened. And so you can use this as a way to kind of shuffle through your evidence as well as a board member. And so that's something to think about as well. Sorry, I just saw Michael put a whole bunch of links up in the chat. So if you're looking for those, please go ahead and look in that chat. They've kind of been buried now under some comments. Somebody asked me to address non-rules violations such as dog attacks. I think I did that, talking about getting the police involved. If there is a rule, if you do have a blanket rule for violations, you may be able to fine for them as well. So that's something to look at as well. I'm going to keep looking at these questions. Michael, do you want to jump in with anything?
Yeah, I mean, I think with pets, there's a broad range of governing document provisions that folks have. And I've seen everything from really clear provisions that say, dogs must be kept under control at all times when in common areas or outside the home. Vicious dogs can be removed from the property, things like that are really extensive. And other times we don't have that exactly. And so you're a little bit more limited in what you can do. And so that goes back to the slide I had. We kind of skipped over it, which is fine, which is to say that you can enforce what your governing documents say, and you can enforce your governing documents, but not other things. So if you don't have anything in your governing documents, and you have, a vicious dog in the neighborhood, there may be nothing you can do other than report it to animal control and the police and rely on them to do something about it. And that might be a reason to amend your governing documents. At the same time, some folks also have a really broad nuisance provision, no noxious, offensive, illegal activity may be carried on the common property. It may say dangerous. It may be broad enough to encompass something like a dog attack or a vicious dog, even if it's a dog that just scares people, a dog that is threatening but hasn't actually injured someone. You'd have to look at that on a case-by-case basis, but there are sometimes things you can do.
I was going to say, I've also seen associations amend their governing documents to deal with certain breeds as well as certain sizes of dogs, so that they can prohibit certain sizes of breeds. Because, while I am a complete dog lover, there is a reality that a big dog can be a whole lot more scary when it bares its teeth than a little dog.
Very true. Very, very true. And another thing folks sometimes forget is that even if they have base provisions in their governing documents, say that a broad nuisance provision or a really broad authority to regulate animals, they don't always have really specific rules or specific fines attached to those things. Mm-hmm. So you may find that even though you could have a rule and a fine related to dog poop or unleashed dogs or vicious dogs, and we keep going to dogs here, but it could be anything, I suppose.
Cats, rabbits.
Right, those vicious bunnies are always jumping out at me. Even if a lot of folks just don't actually have the fines in place that they think they do, or the rules in place that they think they do, and so until they encounter a problem and they come to us and say, hey, we need to find them, we need to do something, and we have to say, yeah, you can't yet. We need to back up a step and make sure you get a rule and a fine in place that's specific enough. And the last thing in the chat here is, does dog urine kill grass? Which I'm no expert, but based on my back lawn and my 2 dogs, yes. It sure does. And
yeah.
It is entirely possible to enact a rule that says, your dogs may not relieve themselves on the common property. Good luck enforcing that, frankly, other than pick up after yourself. That's the poop piece of this.
The poop piece for sure. I think it's really tough, to say, oh yes, well, we've got this beautiful lawn. I suppose there could be rules that pets could only be allowed to go in certain areas, that you have a pet area. And I think that would be reasonable. But and I say dogs because dogs are the ones that go outside, typically need an area. There is one question here about what can the HOA do if there's an owner who's being fined and continues to just pay the fine and basically say, neener, you can't make me change my behavior, I'm paying my fine. Well, in that case, I'm going to say you probably want to contact your lawyer, because there are more steps you can take. If is a continued behavior that is not being changed due to fines, you're going to look at getting a court order for an injunctive relief. And then if the owner continues to violate, they can be held in contempt of court. And so, unfortunately, it can be a costly route to take. But for severe violations, or for owners who continue to cause havoc in an association, it is something that can absolutely be done. I've done it before. I've gotten injunctions, and we have managed to curb problematic behavior and get the owners to come into compliance. It's an unfortunate route you have to take, but it can be done.
Yep. Sometimes it's a choice between either let something continue happening because an owner just isn't compliant, or either let it continue happening or take that next step and go to court and do something that sometimes it seems, frankly, out of proportion with the violation, but at the same time, it's the only alternative step. Now, I will say there is a prerequisite before you go to court for a violation, unless it's an emergency. something really emergent's happening and you need a court order very, very quickly, or property is going to be destroyed or someone's going to be hurt or something like that. There's a requirement that you offer to use dispute resolution, mediate basically with an owner. And that's true other than collections. That's true anytime an owner and the association end up in an adversarial situation and somebody wants to file a lawsuit. So you have to offer and they have to accept. It doesn't mean you have to resolve it that way, because oftentimes it just doesn't resolve, but you've got to offer it. And if they accept, you got to sit down with a mediator and give it a shot. And there's a lot of options for mediation. There are professional mediators, and basically you end up paying a lawyer to mediate.
Or a judge, a retired judge.
The retired judge, those are my favorites because they tell everybody what's what, and everybody tends to listen to them almost no matter what they say, because their experience lends a lot of weight. It's not cheap, but it can be very effective. There are some free services out there, some neighborhood mediations. If you talk to Ashley or I about your situation, we're likely to recommend you don't use one of those, especially if you're in a serious situation. I mean, maybe Ashley's about to disagree with me. I'm not sure.
Well, I'm not going to disagree. I was just going to put a plug in that, I've actually been surprised to see mediation resolve some issues, and successfully. I do recommend a skilled mediator. Usually that means paying for one, can yield better results. But sometimes when it's, owners, they want to do the free thing. And I've seen that be successful as well, but I don't typically recommend it. So yeah. I agree with you, Michael.
There are some circumstances where, those free mediations, you're not likely dealing with a lawyer who's doing it. It's just somebody has some training as a mediation, although sometimes it might be. But sometimes all it takes is somebody to get everybody at the same table. And once you're talking to the owner, that really is all it takes. And it doesn't actually take serious professional intervention. And communication does the trick.
There's a great question here. Sorry, I want to jump in before our time runs out. There's a great question. There's a homeowner who's throwing dog poop over their fence into a common area. And nobody's seen them do it, but everybody knows it's happening. And so I guess my first question is, how does everybody know it? How does everybody know which owner's doing it? I mean, let's look at the evidence. That would be the first place I'd start is look at the evidence. How do you actually know which owner's doing it? And then I think you send a notice, assuming that it's, because typically governing documents don't allow dumping of garbage in common area. And I'm sorry, that's dumping of garbage in common area. And you can end up sending a notice, and if you have a fine schedule, fining for that. If you don't know who's doing it, there's a couple ways to deal with this. My first suggestion is you go around and you knock on the doors of the people you think people have a dog and you think it is. You're really nice, you're neighborly, and just say, hey, we've been getting some complaints, about dog poop in the common area. We want to make sure that you're not dumping, and that it would be a violation. And we just want to make sure, we don't really know who it is, but we want to make sure everybody's on notice of it. You can be neighborly, or just send out a neighborly letter to everyone as well, just reminding everyone that you cannot dump anything, including garbage, in a common area, if that's indeed the rule they're violating. Those would be my main suggestions. Michael, any other suggestions?
Well, there's a lot of different types of evidence, and all you need is enough to convince a judge, really, or an arbitrator, if that's where you end up,
or enough to convince the owner to knock it off.
Right. And it may well be that it's right on the other side of their fence. There's no one else nearby. It may be completely obvious, even if nobody's seen it, or maybe somebody has and they testify. Those are all options. And worst case scenario, dog poop DNA tests to match it to the dog exist. It
matches it to the breed. So if you have everybody has a Cocker Spaniel on that road, you're probably out of luck. but the odds are that that's not the case. And you know who you think's doing it. And you can, testing the dog poop to really, when this came out like 12 years ago, I thought it was insane, but it's come in handy.
You know, thankfully, I've not run into a situation where we had to do a DNA test on anyone's dog poop, but I've mostly just read about it in uppity high rises in Manhattan, you know, where somebody's dog poops in the elevator all the time and they really need to figure it out. But yeah, I have a suggestion of a critter cam to catch them doing it. If it's a persistent enough problem and you really don't know, you could certainly invest in something like that.
A critter cam, there's video cameras everywhere. I'm still not sure I'm a huge fan of it, but it is a way, and it's being done more and more and more. So yeah, we've got about 2 minutes left. Michael, do we want to kind of wrap this up, leave people with closing thoughts? Wow, that picture's amazing.
You're welcome. Yeah, we put poop in the title just to get everybody to pay attention, but it is a real thing, and
real problem.
From my perspective, whatever context we've talked about everything in today, it's all very broadly applicable in terms of, the COVID stuff, of course, and pools and the specific regulations, but in terms of enforcement, it's not just pet and poop. However it comes up, the same procedures apply, the same principles apply in terms of needing a rule, needing to know what your violation is, needing a fine. So hopefully you can take away from this some broadly applicable ideas that'll help you deal with enforcement issues as they come up, poop or not.
Yep, absolutely. And we've got our email addresses there. So if you've got questions or you have issues that you want to, you want to contact Michael or I about, please just let us know. Feel free, reach out. We're here. And we've dealt with poop and way worse issues. So we're ready to help.
Indeed.